Hi.
We're back.
We are.
And today we are going to talk about something we haven't talked about yet. We're going to talk about bankruptcy. Now, our firm doesn't handle all the different types of bankruptcy, but we mainly practice in Chapter 7 bankruptcies. Can you tell us a little bit of what Chapter 7 bankruptcies are?
Yeah, so Chapter 7 bankruptcy is basically where it's called the liquidation bankruptcy because you liquidate non-exempt assets. So you have certain exempt assets that you get to keep, but then everything else gets liquidated to pay your creditors.
And what if, like your house or your car, it's collateralized? So you have a mortgage, but it's collateralized by your house, or you have a car, but you have a car loan. What about those?
So you can either have those included in the bankruptcy whereby you can sell them to pay for certain debts, because sometimes those big ticket items like a house or a car are why you are in so much debt. So you could sell to pay debts down, but usually your house and your car are exempt as long as you're current on those payments. So the equity in them and the asset itself, as long as you're continuing those payments, is exempt and you get to keep that even in a bankruptcy. However, if that's the source of your angst, that's where you're losing your money, it might make sense to sell that in order to not have that burden of having to pay those mortgage payments or that loan for that item. But normally, people will get to keep their house, they'll get to keep their car, the really important things that most people want. Okay, so now that we know more about what bankruptcy is, what is a discharge? What does it do?
So after you get done with the Chapter 7 bankruptcy, you'll get what you consider a discharge, or it says it's a bankruptcy discharge. And what that means is that those debts are no longer due. So anything that was discharged means you no longer have to pay, and you kind of start over. You have a fresh slate at that stage. So that's great. And how you get that is you have to go through the court process. So bankruptcy is a federal court proceeding. So you file in federal court. You don't do it in state court. You file a petition that says you're filing a petition of bankruptcy. Then you have to file some forms similar to like financials, stuff that explains why you need to file for bankruptcy. You have to take a credit counseling class. You attend a 341 meeting where the trustee talks to you about what you put down on your forms, like what kind of assets you have, what kind of debt you have. And then most times, not always, but most times, no creditor shows up. They have the opportunity to come to your 341 meeting, listen to your answers, see if there's any other things that you forgot to list or something to that effect. And then if not, or if the creditor doesn't show up, the trustee will recommend that your bankruptcy be approved and you get a discharge letter.
Great. And a lot of people, I think, have the theory that this is a really emotional process and it's really burdensome and it's complicated. But with the help of an attorney, it's not really that complicated. And a lot of people are scared of that meeting, of that 341 meeting.
Sure.
Should they be scared? Why do we tell clients don't be concerned about this meeting?
Like I talked about before, very few times does the creditor actually show up at the 341. The main thing, and we talk to our clients about this, is be truthful. Don't forget something or, I don't want to include this on my forms. That's what's going to get you into more trouble than having it on the form. Because most times the trustee is just looking for assets that they potentially could sell to relieve some of the debt. And most times they're going to be like, no, it doesn't make sense. It's not cost effective for me to take that to sell it to give back to your creditors. And so you end up with most of your stuff anyway. But what will happen if you're not truthful, or if they think you're trying to hide something, they could say, no, we're not going to approve your bankruptcy at all. So the key is just be truthful and, lay out all of the assets and debts that you have so that they can get a clear picture of what's going on. Another thing is why do they call it an uncontested Chapter 7?
Right. So uncontested kind of goes back to that meeting you were talking about of who's going to show up. Uncontested means the creditors don't have an issue with the bankruptcy and the trustee doesn't have an issue with the bankruptcy. But to circle back to what you just said, if you're untruthful, then there's cause of concern that they're not going to approve it and it becomes contested because you want the bankruptcy, you want that discharge. They don't because they think you were being untruthful or you were being untruthful. And I think this, if we stem this back to an initial meeting with a client, we go through all the assets, we go through all the debts. Now, a lot of people want to hold back certain things, like how would they ever know about the gold bars I have in my safe? How would they ever know about the money that I keep under my mattress? Well, if you don't disclose everything. You disclose that ring of your great-great-grandmother if it's worth anything, because you want to be overly, you want to expose all of your assets because you don't want it to be contested. You don't want anyone to fight it, because if you do it properly, you should have exemptions that will safeguard a lot of your property. So I think when people get really upset about bankruptcy, they get the angst of embarrassment, or it's going to be too long, or my credit's going to be ruined, or I'll never be able to come back from this. And what they really should be concerned about is telling the truth, because a bankruptcy in itself isn't that bad, right?
No.
It's really good. It's a new start for someone. And so while you might have this theory that, oh, I'm embarrassed of this, or I can get out of this, I just need more time to get out of it. Most people say after a bankruptcy, our clients will come back and say, I feel so much better.
I wish I would have done this before.
I wish I would have done this sooner.
Right. You just have to get over the mindset that, like you said, I failed. I didn't do this properly. Sometimes life just happens. And the best thing to do is meet with somebody that's gone through this process before. Most of our clients have never went through this before or known anybody that's went through it. And they just don't know what to expect. So to talk through it with somebody, and they can explain what the process is. They can talk to them about the assets. Maybe it's not the right decision for everyone. Maybe there is other ways that their debts could be paid, or they're just not financially literate, shall we say, and they just needed some guidance on like what to do first. We have clients like that. And then sometimes it's just like, no, you weren't expecting all those medical bills. What can we do to help you relieve the stress of this?
Right. I mean, you're already dealing with a medical incident. Now you have all these bills. How can we best deal with it? But that being said, timing is really everything in bankruptcy.
For sure.
Because if you have these ongoing bills that you're just going to keep incurring, even if you get that discharge, they're going to just keep coming. So timing on bankruptcy is really important, because what happens if you file too soon?
Right. And then you get a fresh slate only to be piled with crippling debt again.
And then you can't file for bankruptcy for another 8 years.
Right. So that is the thing to think about, is you can file for bankruptcy, but then you cannot file for it again for 8 years. So people are like, oh, I'll never have credit again. Well, yes. Sometimes actually you get some credit cards that will come right as soon as you get your discharge. That's because they know you can't file again for 7, 8 years. So that's why you get people that as soon as they get their discharge, they may get a credit card in the mail and they're like, oh, I've been approved, because they know you can't file for bankruptcy again for 8 years. So you're not that high of a credit risk at that stage, because they're not worried about the threat of bankruptcy. Now, when you get closer to your 8 years, you may see them be a little more skeptical of extending you credit at that stage, even if you've been a stellar credit since your bankruptcy. So just things about timing to think about.
Yeah, and not to say that you wouldn't, because you can rebuild credit even within a year. You can still start rebuilding that credit within a year. And some of our clients will even get a mortgage in 3 to 4 years. Right. So it's not getting you out. I mean, it's not that you have hit a dead end and, your life is over because you have this bankruptcy. You can rebuild pretty quickly in the grand scheme of things. So a lot of people, again, are they're scared it's going to be public. A lot of the times nobody even finds out about your bankruptcy. Many people are scared that maybe their employer will find out, and that is a possibility, because maybe they have to verify you're even employed. So they might be notified that way, but usually you can talk with the court and the trustee to say, hey, can we try to keep this as public or as private as possible to avoid any type of other person or other entity knowing about it.
Correct. And that said, it is a public filing. So when you file for bankruptcy, it is a public. So if somebody was really looking for it, they could potentially find it. But if no one's looking for it, then it's not like they notify everybody, or it's in a location that everyone's going to find out. So you can alleviate some of those fears for people. We've talked a little bit about timing, and it's good to give people an estimate of how much time this will take. So we're seeing from the time you file a petition to when you get your discharge to be anywhere from 3 to 4 months. So it can happen fairly quickly.
Yeah, and that's 3 to 4 months from the actual filing, which is
Right.
not when we meet with a client, because sometimes it takes a lot of work and a lot of time to get us all of the information we need, because we're looking at all of your assets and all of your debts. And if you don't have that ready at the meeting, then the process could take a little longer because you actually have to get those. But yeah, 3 to 4 months is nothing to have a clean slate. But going back to the meeting, a lot of people will think that this meeting is going to take hours. How long does a 341 actually take?
It could take as short as 10 minutes. I mean, if you have properly documents filled out, they're going to ask you a few questions based on that. You'll know the answer as you attested to the form, and it's pretty quick in and out. Again, most times there's no creditors. There potentially could be a creditor there that day. Times where you see potentially a creditor showing up as if there was a credit card, and right before you filed, you went on some big trips or some big spending, kind of like you knew you were going to file for bankruptcy, so why don't I spend up my credit card? They may show up at that stage and try to say, no, they didn't do this. They did this fraudulently, or they were trying to deceive us because they knew they were going to file for bankruptcy, so they ran up all this debt.
Yeah, and so when we say you have to be honest with the answers, we're not only talking about the assets. I know we already talked about make sure you disclose, but we're also talking about leading up to bankruptcy. You don't want to put huge purchases on a credit card and run that up. You don't want to loan money or give big gifts to other people. You don't want to do any of those things because it's going to look suspicious like fraud with you doing them, and it's only going to call into question the legitimacy of your bankruptcy.
100%.
At the same time, so go ahead.
Oh, I was just going to say they can look back. So they will look back and see if there were any events or transfers that happened that look suspicious. And then if it's for a family member, if all of a sudden there's money going to a family member, they'll look back even further. So that it's not like they just take the word for the documents you provide and it's a set in time. Like this is what's going on at this minute. They will look back to see what you've done in preparation for filing bankruptcy.
Correct. And that's kind of goes back to our main point of timing is everything, right? If you need to make a gift because you actually need to make a gift, you might need to wait some time before you do it or have a justification of why that gift happened. At the same time, we also talked about exempt assets. So we talked about your house and your car, but there are some things that are not exempt. So for instance, taxes. If you owe taxes, the IRS is not going to give you a pass on your bankruptcy because you have taxes. Of course, you can always go into the IRS and get a payment plan and do a meet and confer with them to help with those tax payments or lower it or whatever it needs to be, but you're not going to get those taxes discharged. You're also not going to get your child or your alimony support discharged. Those are ongoing obligations that you still have to meet.
Ones that near and dear to our hearts, student loans.
Student loans.
Student loans are very hard to get discharged.
Yes, they're not impossible, and it's actually becoming more common to get them discharged, but they still, most likely, they're not going to discharge your student loans.
Right. You have to show that you have no ability to make that payment back.
Right. So it's possible, though not likely, but.
Big ones that often come off, medical bills. So if we have medical bills, you can see them, credit card bills, any of your unsecured debt.
How much debt do we need to file for bankruptcy?
So there's no set amount of debt that you have. It's more of a ratio from the income you have and if you're able to support the debt that you have. So there could be people that have a lot of debt, but their income and their wages, they are able to support paying that debt. But then there's some people where it's crippling debt, where they can't even make the minimum payments, that they can never get ahead. They don't see any foreseeable way that they can get ahead. That's somebody that maybe wants to file for bankruptcy sooner rather than later. Why keep treading water, going under every month a little bit more if we could just get a clean slate?
Yeah, and so the court is going to look at what we call a means test, and that's going to look at the income you have compared to the median level income level in your area, being your state. That is going to give them an idea of whether you qualify for that bankruptcy or not. Now they're going to look at your expenses, similar to what you already said, but essentially they're going to use that means test to see if you even qualify. If you can't pass that means test, you don't pass the mean test, then and you don't qualify for the bankruptcy, unfortunately, you're not going to be able to file.
And we've talked a lot about uncontested bankruptcy. Then what happens if it becomes contested, or what does it mean to be contested? That means one of the creditors shows up at the 341, or that is going to contest your filing. They're going to say, this person doesn't deserve bankruptcy, and here's why. Because they want to get paid. And so they're going to say there was fraudulent transfers done, or they're going to say that you didn't act in good faith. So then it becomes contested. So what that means is they're going to tell the court that
they're going to object to
they're-
your discharge.
Right.
They're going to state why they objected to it, and the court's going to make the decision on whether the objection stands or not. There's going to be other steps that you probably have to go through to prove why or why not that objection should stand. And the court, I mean, at that point, you're actually going to have to go in front of a judge because of the objection. So uncontested, you don't really even go in front of a judge. You just have that 341 meeting, and then it's a lot of paperwork. But if it's contested, now you're actually going to have to go in front of a judge to give your side of why
plead your case.
plead your case.
You're going to plead your case, and that will add time to the timeline that we discussed before. So it's going to take, closer to 6, depending on the court's calendar, when you can get in and get that motion heard. Other questions we hear often is like a husband and wife will come in and just one of the spouses wants to file for bankruptcy. It's like, can you do that? Or is it all or nothing? Do both spouses have to, or can just one of them file?
And normally, I would say 99% of the time we have them file together. And the reason that we do that is because of the joint assets and the joint debts. You can separate them and say, this is, part yours and part mine. But if it's a joint asset, it's going to be affected by that other person that's filing bankruptcy or not filing bankruptcy. So in most cases, it's cleaner just to file the bankruptcy jointly. But there are certain circumstances where you wouldn't file jointly. You would file separately, particularly if you already keep separate expenses anyway. So if you already have separate bank accounts, you already have separate assets, then it might make sense to file separately. But if you already have joint everything, it gets very messy trying to just file bankruptcy for one person because they're still going to look at that joint account or those joint accounts.
Right. And we talked a lot about if your employer is going to find out. But what about, can your employer discriminate against you because you filed for bankruptcy? And the answer to that is no, especially if it's a government employer. However, if it is a private employer, they can have credit, run your credit based for your job application. So if you deal with money, if there's parts of your job where you need to have a certain credit score or credit reliability, they could check your credit, and then it could deter them from hiring you at that stage.
Yeah, and it actually affects whether you can act as certain positions within a court as well. So let's talk about probate. If you've had any type of crime, that's one thing. Bankruptcy is not a crime. But they're going to look at, are you able to handle money? Are you able to handle finances? So it can still show up, but usually it doesn't matter as long as, whatever your position isn't going to rely on you not to have a bankruptcy.
One of the places we have seen it that people need to pay special attention to is with the military, with your clearances. Sometimes the filing of a bankruptcy could affect what kind of security clearance you have. So every job is different, and you should talk to an attorney and talk about what's specific to you, and they can walk through that to see if any employer or if it will have any ramifications against you and your career.
Okay. If we're talking about ramifications, let's also talk about this timing, right? So we said, all right, I can start building credit again within a year, probably. I can probably get a mortgage 3 to 5 years later. I can't file for bankruptcy until 8 years.
Mm-hmm.
But how long is this bankruptcy going to stay on my credit score? And the answer is a long time.
Right.
It's 10 years.
Yeah.
So that's a long time. So that doesn't mean you can't rebuild credit. That doesn't mean that you're going to have, it's going to be haunting you forever, but it will show up in 10 years. So make sure you're mindful of, this, but again, you can still start rebuilding credit immediately. You'll start to rebuild credit within that year. But just know it's 10 years.
It's 10 years on your credit report, and you'll just have to explain it. Like, you'll have to say, yes, I filed this time, and this is the reason why. But you can continue to build credit. You can get a great credit score even with it on your credit report still.
Yeah, and we talked about some reasons why we would file, and we've talked about some reasons why we wouldn't file. If I am facing a bunch of lawsuits, a bunch of garnishments, all of this trying to collect my wages, trying to come after me, I'm getting endless calls, usually you want to file as quickly as possible. Unless, of course, what we've already discussed, that you're going to incur more debt later. So medical debt is one thing, and that's what we see the most of, is an incident created this medical debt that now you just can't get under it. most people coming to us aren't people that are just racking up credit card bills just because they're going on lavish vacations and buying expensive things. Most of them are under crippling debt because of medical bills.
Right.
And so if that medical incident has stopped or, it was a lawsuit, something like that, you want to file as quickly as possible.
Right.
But at the same time, if you have a massive tax refund coming, they can look at that refund that you haven't even collected yet as part of your assets. So you essentially want to file for taxes, in most cases, prior to applying for bankruptcy.
Yeah, your timing matters. And when you meet with a professional, you can talk through that. Again, like they said, they may find that it's not the right decision for you. But if it is the right decision for you, when is the right timing for you? If we're going to continue to incur a lot of debt, there's more medical bills that are coming. Getting a clean slate right now maybe isn't the most advantageous for you over the course of your life.
Right.
However, if it's really weighing on you, say you lost your job and you didn't have health insurance and you had a procedure and it was a one-time thing, you broke your ankle.
And didn't have insurance.
And you didn't have insurance. Well, now you have a lot of bills, but you don't think you're going to have ongoing bills because of your ankle. So maybe it's time to just file right away.
Right.
So those are situations where just timing of everything got ahead of you and you can't get out from underneath the debt. So bankruptcy might be the right decision and the timing of it right now.
So let's talk about cost of bankruptcy. If I'm already struggling with this debt, how am I going to pay somebody to do it? Well, first and foremost, should you use an attorney for bankruptcy?
Right, and that's a great question. So as we explained, an uncontested bankruptcy doesn't seem like it could be terribly hard, right? But you do not have to use an attorney. However, we recommend you do because, like we talked about before, this is the only time or one of the few times that you're going to go through this or even know anyone going through this. When you talk to an attorney, they see it all the time. So they can help you and guide you, help you fill out the forms. It will just be an easier process instead of adding to your stress.
Right, and you want to make sure that you're doing it correctly. We go back to this disclosure. If you don't do it correctly, you could end up in a world of trouble, number one, or lose a lot more of your assets than you intended because you decided that you were going to try to do it yourself. Right. So as far as filing goes, it's a $300 and some filing fee, and then attorneys are going to cost anywhere from $1,000 to $3,000.
Right.
And so they have payment plans, they have pay up front, just depends on who you're going to, but there are methods to get by on making sure that you have the help you need to get you through that process when you need it.
So as soon as you file a petition, you'll see immediate relief. Like the creditors have to stop calling. Or if they do call you or say, I filed for bankruptcy, and then they have to stop. They can't talk to you. They can't keep trying to collect on the debt. So just that in and of itself, a lot of people feel lighter.
Yeah, they're not scared to look at who's calling. They're not scared about the number. They're not scared to listen to that voicemail. They know that the creditors are going to stop while this process is ongoing. And the creditors have 60 days to make a claim. So you have this 60-day wait period to see who's going to actually make a claim. You have your 341 meeting. And in this process, you're relieved. Right. We often hear clients say that they're relieved because the call stopped. Right. So now I have peace, and then you won't have calls.
Yeah, you can breathe a minute. As soon as you file, you're able to breathe. You're able to stop getting these calls, stop having that, and everything. You can make the decisions based on it globally, like what decisions and what. And at the end of the bankruptcy, you should get a discharge, and then they can't come after you for that debt. When you have the 341 and when you fill out the form, the trustee is going to look and see what your assets are. And they're really the ones that make the decisions on what they're wanting to go after. And there is a bunch of exemptions. Nevada is one of the states that has a lot of exemptions, very favorable for the petitioner. And you just have to be able to tell them, okay, these are my assets, but these are the exemptions. These are the reason they're exempt. And then they can't go after them. Then the trustee looks at the other assets to see if there's anything worth of value that they could collect and then liquidize, or if it's an asset that they can able to provide compensation to the creditors.
Yeah. And so now that we've talked about all of the basics of bankruptcy, so you should know more about the ins and outs of it, let's kind of bring it to today. So we had the whole COVID problem, well, the pandemic, and during that time, a lot of people thought, okay, this is going to be terrible. We're going to have a bunch of bankruptcies, but we didn't. Because we had all of those funds being pushed back into us, we were all receiving the stimulus payments. We had the lack of evictions, right? Because people weren't, you weren't allowed to evict them, rather. And so you had all of these things in place that actually didn't allow for that rise in bankruptcy to happen. But now that that money has run out, or the evictions are happening again, we're seeing a more uptick, I would say, in bankruptcies. Now, this is not jurisdiction specific. Some are going up, some are remaining steady, but there is a cause of concern that the bankruptcies are going to start to go up. So while they haven't been super prevalent in a while because we had all of these things that were helping to support us, we're seeing an uptick now. So that's kind of where we're at today. The other thing was, ever since, so post-COVID, student loans, like we already talked about, they're actually getting discharged, well, they're having an easier time discharging them versus what it was pre-COVID. And they've started to crack down on predatory lending as well, whereas that wasn't such a big emphasis prior to COVID. So landscape-wise, it's getting better for people that need to file for bankruptcy, but unfortunately, it looks like we're going to get an uptick in bankruptcies.
That's correct. And then on the bankruptcy side, they're cracking down more on fraudulent bankruptcies or fraudulent transfers. They're spending more time taking a look at that. They have more time right now since the filings are low. Maybe that will change if there's more filings, but right now they have some time, so they are looking to make sure that there's no fraudulent transfers. And the other thing I like to talk about is if you're a business owner, you have a small business, and so you say, the business doesn't need to file for bankruptcy, but me personally am, and I kept everything really separate. That's great, but know that the trustee will look at that, and they will take a look and see if you have really kept everything separate, or if you're running it all one and the same, and potentially your business could be exposed.
And that's what we always talk about on the business side of things, is don't let them pierce that veil.
Right.
And if you don't keep separate books and records, while you thought that it was this creditor that was coming to get you, this liability from the business, it could very well be a bankruptcy that implodes the business.
Right. And just to cross over between the other types of law that we do with estate planning, some people, instead of doing a trust or putting beneficiaries on, they're like, oh, I'll just add my children to my bank account. So it's me and my children on the same bank account. Well, if you want to file for bankruptcy, or if one of your children needs to file for bankruptcy, that's a joint asset. That's now listed on your filings. And that may or may not help you, especially if it's a child that's just on mom's account.
Just for convenience.
Just for convenience. All of a sudden, they're in a position where they need to file. And because of mom's balance in this account, they're unable to file for bankruptcy. We've seen that on multiple occasions. So things to think about how it crosses over into your estate planning as well.